There's no mic at council table, so I'm going to go to the podium with the court's permission.
Yes.
We need to be heard on this.
That's why we're here, Mr. Yannetti.
Thank you. I'd like to start with the most outrageous and false assertion that the Commonwealth made in its motion.
Can I just ask you, there's no jury here, can I just ask you how long this is going to take?
Between 5 and 10 minutes.
Okay.
tops.
Because I don't need, the hyperbole.
Your Honor, I need to make my argument in the way that I think is most effective for my client. I will keep this brief and succinct, but I have points to make that I need to put on record.
Okay, and I'm the person you are trying to convince, correct?
I understand that. The Commonwealth, in a public filing, wrote the following on page 3 of its motion. Quote, during a pretrial hearing on February 15th, when asked by the court whether there was any dispute about a canine's involvement or canine DNA, Attorney Yannetti indicated no, and that the defense was not pursuing such claim. I was astounded to read that for 2 reasons. First of all, it is false. It is a lie. Second, the Commonwealth has knowingly lied about something where it's easily verifiable that they lied. We pulled the tape from February 15th.
I don't have that.
I'm sorry?
I don't have that in my motion.
It's on page 3, Your Honor.
I have the Commonwealth's renewed motion for reciprocal discovery, a motion to exclude defendant's expert, Dr. Marie Russell. I don't see your name at all, Mr. Yannetti. I'm on page 3.
I'm sorry, it's not page 3, it's page 4. My apologies. My name is right there on page 4. It says exactly what I just argued to the court. It's about the 5th line down. It starts during a final pretrial hearing on February 15th, exactly
Okay.
as I said.
Okay.
All right? We pulled the tape from that February 15th hearing. Here is what was actually said. This court asked me the following, quote, while we're talking about DNA, Mr. Yannetti, do we need to be concerned about canine DNA? Where are we with that? I replied, no, I think this is the only outstanding DNA issue. The court then replied, okay, so all right, we're not dealing with canine DNA. And I said, no. There is nothing in there, contrary to what the Commonwealth has represented to this court in a public filing, that I said there was no canine involvement. There is nothing in there, contrary to what the canine represented to this court and to the public, that the defense was not pursuing such a claim. Can you imagine the nerve of the Commonwealth to spin that into...
This is the hyperbole I don't need. Could you please get to the point? We've got a jury coming in 15 minutes.
I understand, but this is... My integrity has been attacked. There have been allegations of bad faith that has been attacked, and I need to defend myself and my client. We were only discussing at that time whether canine DNA was still outstanding, and I succinctly replied, no. And they've spun that, or tried to spin that, into a claim that we're somehow waiving our right to argue that John O'Keefe's arm injuries were consistent with a dog attack. And I ask you, have they no shame? What? Oh, my God! And I ask you, have they no shame?
Wow.
Commonwealth to spin that into...
This is the hyperbole I don't need. Could you please get to the point?
You are listening to the Roberta Glass True Crime Report, putting the true back in true crime. From New York City, Roberta Glass is now on the record.
Okay. How is everybody? Wanted to talk to you today about the defense's big reveal, the text messages of Trooper Proctor, did he get Mark Furman, or was it a big nothing burger? He admits they're inappropriate, unprofessional, no place for them. As a police officer, his text messages, but will they make an impact in this trial? Will it be the distraction that Petty and Eddie and Distraction Jackson need for Karen Reed? Can they convince the jury that Trooper Proctor and Trooper Proctor alone was leading this investigation with his inappropriate self? And we'll get to that. But before, at 8:30, you saw in the opening, we had a hearing that was not to be believed. And of course, it's even being really misrepresented. If you saw the headline going across the screen, that it's all about getting out the dog evidence. No, I read the entire filing this morning. So if you want to go back today, Karen Reed, day 22 in the live section of my channel, and watch the first 10 minutes of the show, I read the entire filing. And what that filing was about for the Commonwealth was that the defense had handed over no information about what these expert witnesses were going to say. What's their evidence? What are they basing that opinion on? So that Lally can cross-examine them. He gave all that information to the defense. He's been asking for this information time and time. And when it was brought up, you saw in the opening, oh, do we need to deal with the dog DNA? Oh, no, we don't need to deal with it. And then Yannetti got up there and spazzed out in front of the court and put on an act where he had to be asked to refrain from hyperbole more than once. And I love when she says, I don't have it. And he has to go to his desk, to the defense desk, and break character. It's like, oh, I'm outraged. Excuse me, counselor, I don't have that exhibit that you're referring to. And he has to walk over in a kind of a faux outrage style over to the defense desk. Let's take a look at that. First off, of everything that we're going to look at today, it was a pretty exciting day in court, from the early hearing to Proctor showing up. I mean, we've heard so much about Proctor. We're like, is this guy going to be a monster? We've heard rumors that the defense has some explosive piece of evidence that no one could convict with. And then Proctor comes up and he's a kind of in the beginning of his maybe middle age to like in his 30s, bald guy, maybe. Didn't hardly seem like some planting evidence monster out to get Karen Reed. But did these text messages, where he's very harsh with Karen Reed, show some kind of prejudice against Karen Reed? The problem with the showing prejudice, so I think what they're trying to do is, which is the famous innocence fraud claim always, one of many, but a really popular one, is that the police had tunnel vision and they didn't look at anyone else. But it's so ridiculous in this case. Who were they supposed to look at? They were supposed to go into the Alberts and look up their torn up floor that wasn't torn up and all this stuff. And there's no room. There's no room in the timeline to plant the evidence. So if the jury's paying attention, if the campaign hasn't seeped into the courthouse, which I'm very afraid of, I don't see how Karen Reed can't get convicted if those things didn't happen. if this innocence fraud campaign has seeped into the courtroom, then I won't be surprised at all if we get a wonky, weird verdict, either some kind of acquittal on all counts. I can't even imagine. Or acquittal of big counts and some small counts like DUI. I don't know. I don't know. I think that it's not from Karen Reed's own mouth to so many witnesses. I hit him. It's my fault. Did I hit him? Could I have hit him? He's dead. He got hit by a snowplow to multiple people. I mean, what are we talking about here? So let us get into the hearing this morning. Shall we? So this is about 5 witnesses that the defense hasn't handed over any of this. It's sort of a dirty trick. And it's a little bit like, if you saw Yvette in the opening, a little bit like thou doth protest too much. You know, he's so outraged that they think that we're not acting properly. No, you're not. You're not acting properly. Somehow everyone on this side of the fence was convinced that the dog DNA, because no dog DNA was found on John O'Keefe, that the dog theory was out. Boy, was everybody surprised when Yvette, including Lally, stood up and said in his opening that John O'Keefe was attacked by Chloe, the dog. Luckily, Lally had an expert to come in and talk about the lack of dog DNA. Otherwise, she probably wouldn't have been called. So let's take a listen to it. So they said that they're only going to call 2 of the experts, 2 of the mechanics, meaning accident reconstruction experts, and perhaps the other 2 aren't going to be called. So Marie Mitchell and the 2 accident reconstructionists. And spoiler alert, the judge ruled exactly how I predicted, which I think was completely unfair to the prosecution. We always talk about the defense's rights being violated, but Lally has a right to get all the information he needs to craft a cross-examination, not a week and a half before it happens, while he's trying this case alone, pretty much. He's the only one up there. He can't hand off his cross to someone else like David Yvette can. David Yvette has Jackson and Little to hand it off to. So let's take a listen.
Lally.
Morning, Your Honor.
Oh, I'll hear you, Ms. McLaughlin.
Essentially, the Commonwealth is just seeking that the defendant produce what the Commonwealth is entitled to under Rule 14 and what every criminal defendant in the Commonwealth of Massachusetts must produce to the prosecution. It was not until the day prior to trial on April 15, 2024, that the defendant provided notice of all their experts. The Commonwealth filed a renewed motion for reciprocal discovery, and the defendant was ordered within a week to produce the expert opinion testimony that the Commonwealth is entitled to. We are now entering, I believe, week 8 of the trial. The Commonwealth has not received any intended expert opinions, anything that those experts, any written reports, opinions, or anything that those experts have based their opinions on. Essentially, the defendant's strategic decisions not to retain their own expert, but rather rely on the U.S. Attorney's Office investigation does not alleviate them or relieve them from their Rule 14 obligations. As it pertains to
So what that means is, and memo to myself to not breathe into the microphone at 8:30 in the morning. Sorry about that. I hope it didn't blow out anyone's eardrums. Is what they're saying is the defense has said, well, our experts don't have reports. They're just going to critique the Commonwealth's reports and not give any sense of where they're going. So Lally doesn't know how to cross-examine them because it's his own report and he doesn't know what their issues are with that report. This is all Rule 14 stuff. So they have till the end of tomorrow to produce this stuff, exactly how I predicted. If I think the judge should have said no. But I think this is another thing that the public pressure does, is had she said no, then all the free Karen readers would have been like, oh, sham trial, denied rights. But really, it's the Commonwealth that's been denied their Rule 14 rights here.
Dr. Marie Russell, the Commonwealth did not receive notice that she's an intended expert until about week 6 of the trial on May 21st. And it wasn't until May 30th that the defendant provided a brief synopsis of what her expected testimony would be. Essentially, and looking at the balancing tests set forth by the case law, the Commonwealth was extremely surprised by this disclosure. And further, the Commonwealth would put that the defendant's delayed decisions to produce reciprocal discovery is in bad faith. It is intended to ambush the Commonwealth and conduct a trial by surprise. We are still receiving reciprocal discovery. Over the weekend, we received additional photographs that the defendant intends to use.
Right. So this got them moving. When they were accused of bad faith, the defense got moving and started giving them things in drips and drabs. They should have had all of this long ago. And this is a theme with this defense. Because they don't have anything really to prove Karen Reed's innocence. I'm sorry, an upgraded phone and some butt dials do not prove anything. And we are still waiting for Ian Whiffen, the Cellbrite expert, to talk about how it's an open browser. But if the free Karen Reed people are paying attention, all their main talking points have been debunked, except that one so far in court. Where's the shoes? Oh, there's the shoes. Where's the belt? Oh, there's the belt. Oh, the car was taken at 4:16 from Karen Reed's parents' house. And that's when Proctor had the car. No, Proctor and Buchanan were following the car. And they didn't get it until 5:30, and way after, with the car, way after the CERT team at 4:56 had already arrived. There was no time to plant evidence. It's all, I just feel like the latest thing is the Sally Port video. I saw a news piece about how it was all meant to fool, and yet that's how it was filmed. If they turned it around, they would say you messed with evidence. You just can't win with this defense team. They're just in the weeds, in the minutia, and that's very common for these kinds of what I call innocence fraud campaigns. They want you to pay attention to the minutia so you can't see the forest for the trees. You can't see the important points. The minutia becomes so important that you can't see the big picture. Karen Reed said she dropped John O'Keefe off. No one saw him go in the house. His cell phone never moved from under his body. Her taillight was cracked. We saw it on the camera at 8 something in the morning. What was it, 8:38? Correct me if I'm wrong. In the morning. So obviously, and when you can see when she hits John O'Keefe's car, she's purposely making her own evidence. And I'm going to get back to that in another episode, I'm going to talk more about her theatrics, more about how Karen Reed really planned out her defense from the minute she hit John O'Keefe after calling him. And I love the argument that the Karen Readers are arguing, which is Karen Reed would have never left those angry phone calls if she really hit him. It's too dumb. Really? Really? OJ would have never killed his wife and Ron Goldman right before he had to take a trip. It's not logical. It's not rational, these things. They don't do what's murderers and convicts don't always do the logical, rational, best thing for themselves. Otherwise, they wouldn't be on trial. All right? Let's put it that way. Or they wouldn't be convicted.
The Commonwealth is extremely prejudiced by these delayed disclosures. So looking at all the balancing factors, exclusion of Dr. Russell is really the only remedy that's appropriate given that we are in week 8 of the trial. The Commonwealth cannot seek a continuance. The Commonwealth is has their hands tied with how to effectively prepare for cross-examination of that witness as well as all the other witnesses. We don't have any materials. We don't know what the experts' precise opinions are and what they were testified to. And it's essentially, it is in bad faith.
That's the judge breathing into the microphone. Now I'm thinking that may have been the judge at the beginning. It might have been me. Anyway, that's that sound, that really heavy breathing sound. She's breathing right into the microphone.
No less severe sanction. So the Commonwealth would move to exclude Dr. Russell. And at this point, we are essentially just seeking the reciprocal discovery that the Commonwealth is entitled to be able to effectively prepare cross-examination of these witnesses so late in the game. Thank you very much.
All right, who's arguing this for the defendant?
There's no mic at council table, so I'm going to go to the podium with the court's permission.
Yes.
We need to be heard on this.
That's why we're here, Ms. Gianetti.
Thank you. I'd like to start with the most outrageous and false assertion that the Commonwealth made in its motion.
Can I just ask you, there's no jury here. Can I just ask you how long this is going to take?
Between 5 and 10 minutes.
Okay. Because I don't need, the hyperbole.
Your Honor, I need to make my argument in the way that I think is most effective for my client. I will keep this brief and succinct, but I have points to make that I need to put on record.
Okay, and I'm the person you are trying to convince, correct?
I understand that. The Commonwealth, in a public filing, wrote the following on page 3 of its motion. Quote, during a pretrial hearing on February 15th, when asked by the court whether there was any dispute about a canine's involvement or canine DNA, Attorney Gianetti indicated no, and that the defense was not pursuing such claim. I was astounded to read that for 2 reasons. First of all, it is false. It is a lie. Second, the Commonwealth has knowingly lied about something where it's easily verifiable that they lied. We pulled the tape from February 15th.
I don't have that.
I'm sorry?
I don't have that in my motion.
It's on page 3, Your Honor.
I have the Commonwealth's renewed motion for reciprocal discovery, a motion to exclude defendant's expert, Dr. Marie Russell.
Did you guys catch his angry strut to the defense table? Did everybody catch that? He's got to stay in character. This is all stuff that the defense has done. Lied. Excuse me. Lied. And we're going to get into Proctor's testimony in a second. But I just want to watch a little bit of this because I think it's super interesting and I don't think it will be covered by other channels.
I don't see your name at all, Ms. Gianetti. I'm on page 3.
Sorry, it's not page 3, it's page 4. My apologies. My name is right there on page 4. It says exactly what I just argued to the court. It's about the 5th line down. It starts during a final pretrial hearing on February 15th, exactly as I said.
Okay.
All right? We pulled the tape from that February 15th hearing. Here is what was actually said. This court asked me the following. quote, while we're talking about DNA, Mr. Yannetti, do we need to be concerned about canine DNA? Where do we stand with that? I replied, no, I think this is the only outstanding DNA issue. The court then replied, okay, so all right, we're not dealing with canine DNA. And I said, no. There is nothing in there, contrary to what the Commonwealth has represented to this court in a public filing, that I said there was no canine involvement. There is nothing in there, contrary to what the canine represented.
Right. It's just this little sleight of hand. We just said we weren't dealing with it today. So we're not dealing with canine involvement? No. Doesn't that sound like we're not arguing that? But these lawyers talk out of both sides of their mouth. Who knows what they're talking about? But suddenly everyone got the impression that the dog was out, except David Yannetti, who thinks that when you ask them, so we're not dealing with the dog DNA? And he says no, that everyone should know that means yes, that we're going to argue it in opening, and then we're going to present an expert. So I guess they're just going to ignore that. So I guess that we didn't ask the right question. You should have said, are you going to still, after there's no dog DNA found, no dog hairs found, nothing found, no sign of this magical dog, that you're still going to argue dog bites? That should have been the question we all should have asked. Maybe then he would have given us a straight answer. You think? Maybe? Is that it? That we didn't ask the right question?
To this court and to the public that the defense was not pursuing such a claim. Can you imagine the nerve of the Commonwealth to spin that into
This is the hyperbole I don't need. Could you please get to the point? We've got a jury coming in 15 minutes.
I understand, but this is my integrity has been attacked. There have been allegations of bad faith that has been attacked, and I need to defend myself and my client. We were only discussing at that time whether canine DNA was still outstanding, and I succinctly replied, no. And they've spun that, or tried to spin that, into a claim that we're somehow waiving our right to argue that John O'Keefe's arm injuries were consistent with a dog attack. And I ask you, have they no shame? I'm sure it's not lost on this court that this falls.
Have they no shame? This is David Yannetti, who spearheaded a witness harassment campaign along with Karen Reed and Alan Jackson. How dare he? How dare he? But that's what they do. That's what these campaigns do. They turn everything on their head. It's not us who's lying. It's the Commonwealth that's bad, so bad. It's not us that's protecting a murderer. Everyone else is protecting a murderer. It's the ultimate projection. Blame everyone else. That is how these campaigns are run. Have you no shame? Have you no shame, David Yannetti? We've seen the search warrant for Karen Reed's phones. And that's the big question mark. Did she have more than one phone, and did she only hand one over? Because she sure had two phones by the time she was involved with Turtle Boy, and David Yannetti and Alan Jackson all spearheading this witness harassment campaign and PR campaign and trying this in the court of public opinion.
False filing by the Commonwealth comes on the heels of their nefarious attempt to pass off an inverted video, a false video, before this good jury hearing this case.
See, this is really for the free Karen readers. Hey, guys, everybody get upset about the inverted video. Tell me what difference would that make, that if it were the other way? And it was, and Alan Jackson presented it the other way. What difference did it make? The only point was that the time it was in the Sally part, how they preserved the evidence, and none of that matters whether it's mirrored or not. That was the point of that evidence. The only people that made it about the taillight and Proctor were the defense. And it's, with the timeline, physically impossible for Proctor, and we heard with his testimony that he wasn't at 34 Fairview on January 29th. So what are they talking about?
Never once during the direct examination of Sergeant Buchanan did they inquire or mention the fact that the video might
Can we please, all right, I'm going to stop you. Please direct your comments to Rule 14 and the reciprocal discovery obligations that the defense has. That's what this motion is. I know you have a speech you want to make, Ms.
It's
Giannetti.
not a, Your Honor, it's most respectfully, it's not a speech. It's
Okay,
it's
so-
a defense of being alleged to have committed bad faith.
So you've moved on from that. So please just focus on Rule 14 and let's do it in two separate parts. So you've changed, you're not calling Frank Sheridan,
No,
right?
we are calling Frank Sheridan.
All right, so you've got a new medical, Dr. Russell. We'll do that part of it separately. Tell me about what you've provided the Commonwealth on Chris Van E.
They've gotten his CV and they've gotten the substance of his opinion from us. And they've had that for a long time, and the court, I believe, has already.
Right. That's not enough information. It's not enough information. Okay, you guys get the idea. It went on, but I wanted you to get a sense. Goes into Chris Van E. They didn't give them anything. They didn't give them enough information to do a cross-examination. And it looks, I'm wondering now if David Yannetti is starting to rile up the troops for, one could only hope, for any kind of consequence he faces for the way that he orchestrated this campaign way ahead, outside of trial, way ahead of ever arguing things in trial, feeding things to Turtle Boy and then citing them in his own motions. You can't do that. So that should he be cited, he'll have a whole group of free Karen readers to call on to show up at his, I don't know what, his hearings. I don't know what it's about. It's really, if I had to guess, it's really to just rile up the free Karen readers and try to pretend to be outraged. But here comes, before we go into Proctor, let's go back. This is something that one of my favorite channels, Innocence Fraud Watch, put together. Did a little blast from the past. But let me go back. And this is called
There is simply no.
My apologies. Karen Reed. Lawyer Adam Lally was and still is spot on regarding Trooper Michael Proctor. So these are all the things. This is just a reminder. I feel like the free Karen readers are like are hamsters who have very short memory span. They seem to forget all the things that they were promised. They were promised that this would never go to trial by Aiden Turtle Boy Kearney. They were promised that the FBI would be coming in any minute and making arrests. They were promised a conspiracy that the defense has not even been able to prove, not even been able to form the basis of any kind of third party culprit defense in this. And here's what an Innocence Fraud Watch smartly went back to an early hearing and pulled Lally talking about Trooper Michael Proctor. So let's take a look at this before we look at his testimony, or some of his testimony.
There is simply no evidence of Trooper Proctor having a close connection with the homeowners. There is simply no evidence. I guess now it's being.
Did you guys hear that? He got heckled. He got heckled in court. And you can see there's Karen Reed's brother. All the free Karen readers in the front row. Is that Aiden Kearney to the left there? All ready to heckle him. And we found out through his testimony that this was absolutely 100% the truth.
Position that he was sprinkling tiny pieces of a taillight, pieces that I described to the court earlier as less than 1/16 of an inch that were embedded within Mr. O'Keefe's clothing.
So that's a good reminder. Let's get into the beginning of Trooper Proctor's testimony today. So in the beginning, I'm going to skip forward to the beginning, to the part that everybody's going to be talking about, and which is sad because he showed the taillight from Karen Reed's car, put that into evidence with the box that was in and the bag that it was in. So some of the physical evidence. And he talked about this investigation and how it came about. And obviously, you know, I'm watching the trial and I'm having ill feelings towards Karen Reed. She seems to have no emotion. She spearheaded a harassment campaign. Just looking at the state of John O'Keefe's clothes makes me very upset and angry. So you can imagine if it's a fellow police officer, how you'd feel. But there's really, as he says, no excuse for these kind of emails except text messages, except to blow off steam. So Lally got out in front of it and introduced the text messages right up front so that there would be no surprise from the defense. And by the time that Jackson got up, to my view, Jackson, he didn't want to talk about the taillight. He didn't want to talk about any of the more important pieces of evidence. All he wanted to talk about were these inappropriate text messages. And to my eye, I thought Jackson was more helpful to the Commonwealth and really softened the blow. Because here he is doing these grand theatrics about these text messages. When shouldn't he be doing grand theatrics about how it's possible that Michael Proctor could have messed with the evidence or somehow singled out Karen Reed, or everyone hated Karen Reed and wanted to put the blame, all 90 plus people, in this conspiracy? It's absurd. It's absurd. The defense theory is absurd in this case. And to watch the press just jump on it for clicks and views is is this what we've gotten to? Has our news organizations just become entertainment and the most salacious story they go with? Because Court TV's idea of fair and balanced is to have 3 pro-Reed Karen people on and one Karen Reed is guilty that no one listens to. It is painfully obvious when they're getting witnesses' names wrong and no one's saying anything because nobody's listening. Everybody's just waiting to talk. Nobody says, who testified today? Who was that? Everyone's just waiting to talk in these panel discussions. All right, let's take a listen.
Labeled Proctor friends.
Now, over the course of your investigation, over the course of this case, are you aware that there were iCloud data that was obtained from your personal cell phone?
Yes.
And different text strings from that iCloud data from your personal cell phone, correct?
Correct.
And with respect to what has just been placed before you, is that an excerpt or piece from those particular messages?
It is.
And from the front page of that, can you tell the jury who are sort of the participants in this particular text communication?
There's several numbers that aren't identified. The 3 that are under kind of nicknames me and my buddies have for each other.
And generally speaking, just as far as the participants in this text communication, who are these people to you, and how do you know them? How long have you known them? Who are they?
The members on this text thread are close friends from junior high, first grade even.
So people you've known for years, is that correct?
Correct.
And do each of them live, or do any of them live within the general area at this time?
Some of them do, yes.
And so when some of them do, some of them do not, is that correct?
Correct.
And the ones that do not, how far away do they live?
As far away as Tennessee.
Now, with reference to this, there's an indication as far as the first message sent or last message sent from this particular text chain, correct?
I'm sorry, repeat the question, please.
Sure. Sort of towards the middle of the first page. Come direct your attention to that area. Is there any indication as far as the first message sent and the last message sent with respect to this text chain?
On the first page, yes.
And what is indicated as far as the first message and the last message?
The first message is, I need to brandish a gun more often. The last is, Chip, name of that BPD cop.
No, I'm sorry, sir. If I could direct your attention to the first page in this packet, page 2527, you see conversation details. I'm sorry, sir, may I approach?
Yes.
If I could direct your attention to the right.
Okay,
Do you see what I was talking about now?
I do, sir.
And from that area labeled conversation details, there's a first message sent date and time and a last message sent date and time, correct?
Yes.
What is the first message sent date and time?
It's 10/18 of 2021 at 8:48 a.m. The last message sent is 8/31/2022 at 11:19 p.m.
And is there also within that conversation details an indication as far as number of messages over that time frame within this communication?
There is.
And what does it list for number of messages?
It's 38,707.
It's fair to say the packet that you have before you does not contain all 38,707 messages, correct?
That's correct.
The first message that you had, I believe, alluded to in reference to the first one listed within this communication, what date and time is that?
That was January 29th, 2022 at 10:36 p.m.
And who is that message from?
My friend who lives in Tennessee.
And what, if anything, did he send to the group?
I need to brandish a gun more often.
And if you know, what is that in reference to?
He just recently moved to Tennessee, and he was kind of, I think, making a joke as kind of the lifestyle down there where guns are more prominent or more common to be carried around there. So I interpreted that as a joke in that nature.
And the next message, sir, from that same page, 2527.
The next one is, it's bold.
And is there a name associated with that number that's in these?
No,
Do you know who that person is?
I don't.
And the next message, sir, from 10:52 p.m.
Chip, name of that BPD cop.
And Chip, who is that referring to, sir?
That is one of my nicknames I've had since maybe high school.
So a nickname that would be familiar amongst these group of friends in particular?
Yes.
And this time period when these text messages begin, sometime after 10:30 or 10:50 p.m. on January 29th, where are you and what are you doing in reference around that time period?
At this point in time, on the 29th, I'm home.
And that last text message, do you respond to that at approximately 10:53 p.m.?
Yes.
And what was your response?
John O'Keefe.
And the next message down from there, also at 10:53 p.m.?
Yes. He took custody of his sister's kids.
That's your response. There's another response above that, is that correct?
Yes.
And what does that say?
How old?
And you respond as far as he took custody of his sister's kids, correct?
Correct.
Skipping down a couple, do you see an entry at 10:53:49 p.m.?
Yes.
And that's from the 617 number, is that correct?
Correct.
And what is the response there?
Oh man, that's rough.
And following that, do you respond to the earlier query as far as age?
I do.
And what did you say?
Mid 40s.
Now, the next message below that, as far as indication of.
So these are text messages that would, in any other trial, not been brought up. But because Lally knows that the defense will make anything nefarious that slightly sounds nefarious sounding, run with it, he's going to bring it all up before they have a chance to and pull the rug out from under them. So that's what he's doing.
Of mid-40s, what is that?
His age.
No, I understand that. I'm sorry. The next message underneath that, sir.
I'm sorry. It's a Facebook link.
Can you recall what that Facebook link is to?
It's to John O'Keefe.
And is that something you sent or one of your friends sent?
One of my friends sent.
And the next message below, turning to now page 2529 at the top there. What is the next message that's sent?
What's that? Don't have the book anymore.
And as far as the book, what did you understand that to be?
Sure.
So we're finally getting to hear the context of, right. So there's my little comments. It's like doubling my comments, right? We're going through these a lot. There was a lot of, I think they went on a break here. The defense just was totally shocked. I think they had no idea that Lally was going to go this way and bring up all these embarrassing text messages himself. So when they started going down this route, they object completely because it just pulled the rug out from under them. And so what you'll see, what Jackson tries to do is totally Mark Furman him and make him seem like a sexist and that he had something out for Karen Reed and would be someone who would have such bad morals that he would plant evidence. But you have to have an opportunity, at least. I don't know how many people think Mark Furman planted evidence and OJ is innocent. But he at least had the opportunity to. There was a time where he could have. Here, there's no time. There's no time in the timeline to do it. So it just becomes like this kind of ridiculous thing. But, okay. Getting back to Lally's cross. Sorry, let me move forward a bit.
His response was nope. Homeowner is a Boston cop too.
And what, if anything, were you saying, or what was the purpose?
I'm sorry, guys, I went back too far. It's really hard when you have these super big files. My computer just can't take downloading them all this big, so I have to run through them. So anything that could be misunderstood, Lally's going to really have Proctor explain exactly what he meant. Exactly what he meant. This is what I meant. He was a police officer. They said, oh, whoever was in that home, his friend says to him, is going to be in trouble. And it's like, no, they're a police officer too. Thinking that, I don't know if he was aware that it was a storm or whatever when it happened. So I'm sure the defense is going to make much of that. He was a police officer too, though. So that means he's off the hook. That means he's off the hook, guys. Wow. Let me move forward. There we go.
You are
Get the witness
unmuted.
back, please.
Yes, sir.
Proceed, Your Honor.
Yes.
Trooper, if I could direct you back to page 2529 within that packet before you. And below that text stating what's that, I don't have the book anymore. You respond, is that correct?
Yes.
And what is it that you say there?
This one is a nightmare. Forget about the kids. That's awful.
And sir, if I could.
Yeah, if that makes him look bad, then I've said this 100 times. This is the saddest case. I can't believe how sad this case is. This is horrible. It's so dark. Karen Reed is so dark. I've called her a psychopath, an antisocial personality. Thank you, Dean Walker. Appreciate it.
Direct your attention again within that same packet to 2532. And there's a message there sent at 10:56 p.m. Is that correct?
Yes.
And who's that from?
A friend who lives in Tennessee.
And what does he say in that text?
I'm sure the owner of the house will receive some shit.
And you respond at 10:56 as well as 10:57. Is that correct?
Correct.
And what is it that you respond?
My first response was nope. Homeowner is a Boston cop too.
Boy, Proctor called that one wrong, right? I think I had the same comment this morning, but yeah, right? He called that wrong.
And what, if anything, were you saying, or what was the purpose of that text in regard to the homeowner?
I was just letting him know that essentially Mr. O'Keefe is a Boston cop and the homeowner was a Boston cop as well.
Now, if I could turn your attention to 2533. And top of the page, sir, if you could read through.
Did he get beat up?
And you responded to that, is that correct?
I did.
The objection sustained is to form.
What, if any, response did you provide to that?
Nope.
Objection. The objection was to the former question and the answer.
I'll strike it.
Now, turning your attention to 2534. And from this page, sir, if you could again just read through as far as indicating to the jury who's speaking and what is being said.
From the start of the first text, so the owner of the house.
Yes.
So the owner of the house was a woman cop that beat him. That's what I initially thought after talking to Can paramedic. Then I saw the guy.
And those last two are your responses, is that correct?
Yes.
Now, the following text messages are from your friends, is that correct?
Yes.
What do they say?
Bear, let's focus. What does she waffle to mean? What's the story? I responded, she hit him with her car.
And she that
Yeah, this is an unusual case. Like, he thought that this was a beating from a woman, but everyone got that this was some kind of relationship violence from the beginning. So if you're tiny and you're Karen Reed up against a 220-pound person, you're going to use something like your car. But I'm convinced that, and we still haven't gotten to the car data, but what we've been told it shows is that she goes backwards and doesn't stop. So once she hits something, and I think we're going to be shown that her car has some kind of warning when you're about to hit something, either just through the viewfinder, through the center console, or through automatic braking. That's the big question mark that we're all waiting for. Either way, she had a warning. She knew she was going to hit something, meaning she purposely hit him, and she knew she hit him. She never stopped. She never called 911 ever, even the next morning. Everyone called 911 for her. None of her actions were normal. It was all about protecting Karen Reed. And I'm going to talk about that in an upcoming episode, a little bit more about her theatrics and her absolute planning this and planning her alibi. If you think her backing up right in front of the Ring camera, she knew with Brian Higgins where the Ring cameras were. She knew where the Ring camera was to back up and what taillight to love tap to make it look that like the 508 is when she hit John O'Keefe's car, and that's where the breakage was. But her taillight is all over 34 Fairview, and there's no option time-wise for the police to plan it. And no incentive, motivation. Let's talk about that. They all wanted to pin this on Karen Reed and not someone else. Why? Who happens to also be the last person who saw him, who also happens to be the person who said, I hit him, I hit him, I hit him. Did I hit him? Could I have hit him? He got hit by a plow. He's dead. I mean,
That you're referring to there, who was that?
Miss Reed.
Now turning your attention to the next page, 2535. Again, if you could start at the top of the page and read through that page and just indicate to the jury who is talking and what is being said.
Okay. My friend in Tennessee states, okay, that's fucked up. I respond, intentional or not. Then another response, gotcha. He was frozen in the driveway and she didn't see him, question mark. That's another animal we won't be able to prove. And then I respond, they arrived at the house together, gone to an argument.
Anyone speak out loud or out of turn?
The objection's overruled.
Your Honor,
But
if I could say this, there needs to be an identifier of who's
I
speaking.
understand what you think the mix-up is. So, Mr. Lally, go back.
Thank you.
Sir, if you could please, again, start at the top of the page and just indicate.
No,
as
just
you're-
just after the gotcha, he was frozen in the driveway, correct, Mr. Jackson?
That's correct, Your Honor.
I'm not confused at all as to who's speaking. I was confused by this objection, frankly, but okay.
Thank you.
I respond, that's another animal we won't be able to prove. I follow that up. They arrived at the house together, got into an argument. She was driving and left. 781 number responds with, what's the name of the Canton cop living in Canton? The other one involved.
And how do you respond to that, sir?
There's several other messages before I issue a response.
Objection again. Bottom of the page.
So it's not an objection, but Mr. Lally, why don't you point to him?
So, sir, at the bottom of page 2535, you have a response. Is that correct?
Correct.
And what is that response?
They arrived at the house together, got into an argument. She was driving and left.
Objection.
So it's going to be a matter you can address on cross.
There has to be some accuracy. If the reading-
So I understand. So, Mr. Lally, why don't you go point for your witness?
May I approach, Your Honor?
Yes.
Mm-hmm. Okay. It's a HTML link, whiteout /Proctor iCloud /group chat Feb 2022. So you point out.
Can I see what you have for a second, please?
Yeah, sure.
Mr. Lally, it's on there. Why don't you go show your witness? Why don't you just read it, Mr. Lally, and tell us who you attribute it to?
Sure. So, sir, what I'm asking you about is the bottom of page 2535, excuse me, 2535. You indicated biffed him, correct?
Correct.
What did you mean by that?
That Miss Reed had struck Mr. O'Keefe with her vehicle.
Now, sir, if I could direct your attention to page 2537. Now, do you see a response toward the bottom of the page from yourself, January 29th, 2022 at 11:04 p.m.?
Yes.
And can you read that response for the jury?
Yeah, but there'll be some serious charges brought on the girl.
And what did you mean by that, sir?
That throughout the course of the day, we had compelling evidence that Miss Reed struck Mr. O'Keefe with her vehicle.
And you have two responses from friends, the same friends, at the bottom of that page, 2537, is that correct?
That's correct.
And what are those responses?
Keep your voice up loud, please. Trooper Proctor, jurors can't hear you.
Yes, Your Honor. Number ending in 5051. Got to be. I can only imagine what internal affairs of the BPD are trying to get out there. The second response, same number. She hot at least.
And turning your attention to the next page, 2538, at the top, if you could just read a series of responses from yourself, correct?
Yes, sir.
Read from those, sir.
Yep. So these came from me. From all accounts, he didn't do anything wrong. She's a whack job. CUNT.
Objection.
So don't spell it.
Objection. She's known as the weed whacker, and she's not a whack job. She's the weed whacker. You know that if Proctor were Jackson or Yanetti's client, that's what they would be arguing. He didn't mean whack job. She calls herself the weed whacker. It was, it was just a shorthand there. So ridiculous to make him read these, and they're unprofessional, and obviously, someone who has a very long and hard job, who uses text messages to chat with his friends about what's going on. But if he had gone into super detail about how we're going about the investigation, and we're planning things, and we're making sure that she's going to get convicted, or even don't worry, she's going to get convicted, we're making sure of it, that would be one thing. But these aren't the text messages. They're juvenile at times and inappropriate, but they don't prove planting. But are they going to be enough for one juror, two jurors, three jurors, the entire jury, to say we can't trust any of the evidence that comes from all the cops, everybody who worked on this case, because of this one text message? I don't know. It seemed, like I said, more and more ridiculous as the cross went on, which is odd because usually the direct is the less damning part, is where the witnesses are really comfortable. He seemed more comfortable in direct and less comfortable, in cross, and less comfortable in direct reading these things.
So these are your words, Trooper Proctor?
Yes, Your Honor.
Go ahead and say them.
Cunt. Yes, she's a babe. Weird Fall River accent, though. No ass.
And sir, what is it that you were referring to there, or why would you text that?
These were, from all accounts, he didn't do anything wrong. I'm talking about the homeowner, Mr. Albert. I had mentioned the compelling evidence against Miss Reed at this point indicated that Mr. Albert had nothing to do with Mr. O'Keefe's death. The rest of the unprofessional and regrettable comments are something I'm not proud of, and I shouldn't have wrote in a private or any type of setting.
Sir,
You know,
At
but
some
this
point, if I could turn your attention to page 25.
this is the point of Karen Reed. It's the point of Turtle Boy to get your worst moments, your most vulnerable moments, your most private moments, and make them public and expose them. And meanwhile, they're protecting a woman who ran over, not only protecting, promoting the innocence, and that's the way innocence fraud goes. Oh, they'll always accuse the officers of being corrupt, of being dishonest, while running the most dishonest, corrupt campaign. So I'm sure the Free Karen readers are giving each other high fives and thinking this is relevant. But whether the jury's going to see this as relevant or not, it remains to be seen.
4-0. And there's a photograph that's shared within this text communication. Is that correct?
Yes, sir.
And does it indicate who shared that photograph? From the prior page, possible.
The number ending in 5051.
And who is depicted in that photograph that was shared within the group text?
It's Miss Reed being escorted out of the State Police Milton Barracks.
And these are all from February 1st of 2022, around that time frame. Is that correct?
Yes.
Now, sir, if I could direct you to page 2543. And sir, if I could direct you to the top of the page and ask you to read through that page, indicating who's speaking and what the content of those communications are.
Okay. Number ending in 4146. Question is that chick a smoke? Again, 4146 question mark. I respond EH. I respond again, nut bag, as Chief would say. I also respond with she's got a leaky balloon knot, leaks poo.
And what, if anything, is that in reference to? Sir?
Again, to Ms. Reed's some medical conditions there. Again, unprofessional comments I should not have made, that I'm not proud of.
As far as attitudes expressed within these text messages and other text messages, what, if any, impact did that have as far as your investigation was concerned regarding this?
These juvenile, unprofessional comments have zero impact on the facts and the evidence and the integrity of this investigation. They said these are unprofessional comments, but they absolutely do not detract from the integrity of the investigation or the facts and evidence of it.
Your Honor, may I approach this to retrieve?
Yes.
Now, Trooper Proctor, contained within, we've seen text messages amongst yourself and a variety of different people.
And also, Karen Reed supporters also like to forget that she said David Yannetti represented her as someone with a brain tumor when she first appeared, not just MS and her other conditions, medical conditions, but that she had a brain tumor. Totally false. So it looked like they were going to try to go down that route. Because originally David Yannetti was saying this was a tragic accident before they went with conspiracy. No one talks about that. That's what I'm talking about with like the hamster-like memory of this campaign and its supporters. They change their story all the time. They change the suspects from Brian Albert to Brian and Colin Albert to Jen McCabe to they're all in Donna to Trooper Proctor. everyone's the devil but Karen Reed, everyone's lying but Karen Reed, everyone's out to get Karen Reed. And they're all opening up their wallets and supporting it.
From that same sort of iCloud area of your personal phone, correct?
Correct.
And among those, are there communications that you had with members of the Canton Police Department?
Yes.
And how would you characterize, or what was the general content of communications that you had with members of the Canton Police Department?
One communication was to coordinate interview times for firefighters and police officers and to set up a conference room where those interviews could be conducted. Obviously, the presence of Canton detectives or any police officers were not going to be sitting in on these interviews. Another communication was to inquire of relevant security videos that are in the area. Their local department, they know the area very well, so I had reached out and asked if there's some good cameras in the area that I had of kind of interest in.
May I approach the witness?
Yes.
Yes, I do.
What do you recognize that to be, sir?
Text communications between my sister and I.
That's your sister Courtney, is that correct?
That's correct.
And similar to what I'd asked you about the prior packet, as far as a first message sent, date and time, last message sent, date and time, what is indicated on this first page?
First message sent, date, time, December 10th, 2021 at 9:33 p.m. Last message sent, 8:30, 2022 at 8:48 p.m.
And 8:30, that's August 30th, is that correct?
I'm sorry, yes, August 30th, 2022.
And similarly to the other messages, is there an indication as far as how many number of messages were sent between yourself and your sister over that time period?
2,865.
And fair to say that the documents in front of you do not contain 2,865 messages?
Correct.
Now, just in reference to the first message on page 2662, the first page in this packet, do you see that from December 10th of 2021 at approximately 9:33 p.m.?
Yes.
And what does that indicate?
A text message from my sister.
And what does it say?
I called earlier, Dolph earlier, and mom was puking in the background.
And do you recall what that was in regard to?
From the sounds of it, my mother had the stomach bug.
And sir, if I could direct your attention to page 2667. And these are text messages from January 29th, 2022, between yourself and your sister Courtney, correct?
Correct.
And if you could read from the top of the page through the end, and please indicate to the jury as far as who's talking and who's saying what.
So I texted my sister at work, "What's up?" She responds, "What? Why?" I respond, "I just found a frozen to death on a front lawn in Canton this morning. Actually just interviewed Jen McCabe, said she knows you."
And the knows you, who are you referring to?
My sister.
And how did your sister respond to that?
Cut the shit. I responded, "You." It was a typo correction with my response to you. She responded, "Yeah, she knows Jack very well. She's really good friends with Julie." My sister continues on. Her sister is married to Brian Albert. My sister asks, "You still working?" ? I says, "Yeah, going to be out for a while." Homicide.
And as far as your answers to those questions, or as far as your communications that you had with your sister at this time on the afternoon of January 29th, what were those in regard to, or why were you communicating that to your sister?
At that time, it was just kind of in the news. I was just kind of letting her know I was out working. She didn't share anything specific. I wouldn't share anything specific on cases with my family or anyone. It was just kind of an overall innocent conversation.
Now turning your attention to the next page, 2669.
Right. So it's a really good, a really important part to bring up, that he's not sharing anything that they're not reading about, that's not already out there in the news. So I'm going to try to skip forward. There's one part where he says he's going through her phones and she's looking for nudes. He says no nudes, and he says it to his bosses as a joke, didn't find any nudes. And that's what Yannetti and the Free Karen readers have been dining on for months now, or whatever, since the beginning of this trial. I don't know if it's been months. How long has it been? So I'm just going to skip forward to Jackson's, because it goes on like this, just embarrassing, inappropriate text messages. And Alan Jackson tries to go scorched earth on him. So let's see if this is still Lally. Hold on one second. Just trying to get to the back here. You can see that there was a search warrant for John O'Keefe's mom. Looks really unhappy here. But right at the end, we got a little of Jackson going scorched. Feel it's true. Right? Where seems like something malfeasance happened. That's all you need. It's really, it doesn't change the evidence. I mean, they've proved no one else but Karen Reed did it. But this will be talked about in the jury room. And you expect, if you're a police officer, I'd hate Karen Reed. I mean, I'm not fond of Karen Reed just covering this. So can you imagine when you're touching, you're picking up the clothes from the hospital floor, and you see what she did and her attitude, and you're around her. Imagine her up close, how awful she is, how you feel that way. And if you don't think your text messages, you're basically confiding in your cop buddies. You get how it went. You understand how it went. And the younger generation doesn't really have a sense of privacy. I wish they would train these cops. Make a phone call, dude. Go back to phone calls. Get off these text messages. Your phone gets subpoenaed, and you writing inappropriate stuff. It looks really bad, but everybody communicates by text nowadays. It's so convenient. Murder by Maestro doesn't think it was bad at all. Well, I don't know if it's an American thing. I think it just looks bad to have someone those were unprofessional messages. It's BS, but BS can derail trials. I don't know. Let's see how our poll is doing. Okay, 75% say will be enough to get Karen Reed acquittal. Most people said no, and 20% are unsure. So that's pretty good. You guys are more optimistic. I just, that bummed me out, because I know I've seen stuff like this derail a trial. Let's see. Maybe not with this kind of burden, though, of proof. When we take a formal break, I have a Karen Reed song. Yeah, thanks. Messages are nothing. You get investigating trial.
Most it will be half an afternoon or something maybe on Friday, but it does now look good that we'll be able to continue with this.
Did I miss it? Did I go by Alan Jackson? Did we already miss it? I'm sorry, guys. I really thought we were in My apologies. I thought we were still talking to Lally. All right. I don't know. Alan Jackson gets up at the end here and just goes crazy. Okay, here it is. Here he is.
Part.
Poor language is one way to put it. Completely offensive is another way to put it, right?
Objection.
I've got to sustain that, Mr. Jackson.
After you referred to my client as retarded, then you decided to make a comment about Mr. Yannetti, her lawyer, correct?
Correct.
And what did you say about Mr. Yannetti again?
I hate that man. I truly hate that man.
I hate that man. I truly hate him, correct?
Correct.
You didn't say I dislike him, disagree with him. You said I hate him, correct?
I mean, this is so when Alan Jackson gets up there, it makes it look more ridiculous. I don't like. I could say I hate David Yannetti too. Did I frame Karen Reed? Is this jury going to fall for this theatrics? And he just goes to town on this. Gets cut off pretty soon. It's a short little bit with Jackson, but here's a little bit more of it. And then I think I'm going to close this out.
Correct, sir.
That's a visceral response to someone who's just doing a job, correct?
Objection.
Sustained. You can ask it differently.
Sure. Let me ask it this way. Were you upset or annoyed or pissed off that Karen Reed had gotten representation, legal representation, to represent her?
No, not at all. That's her right.
Well, let me ask you this. In August of 2022, you said you absolutely hate it, correct?
I don't know if I use absolutely. Yeah, I didn't use absolutely, sir.
You used truly, correct?
Truly, yes.
How do you feel about him now? He's sitting right there.
I still don't care
Objection.
for him now.
I'll let it stand.
I mean, that's an honest answer. I mean, what do you expect? Who would love David Yannetti? Who would love David Yannetti? That's what I want to know. Who would love him?
What did you tell your colleagues that you were looking for as you sat at almost 10 p.m. at night on a Wednesday night, August 17th, 2022, looking through Karen Reed's phone?
I didn't tell them I was looking through anything. They knew I was going through Miss Reed's phone. I provided a inappropriate joke as an update. They knew I was going through location data, text messages, Google searches. But like I had mentioned earlier, I had to stop.
Except Trooper Proctor, none of that really professional sounding stuff ended up in your comments to your bosses, did it?
Again, it was a poor joke.
Is that yes or no?
They did not know.
It did not.
No,
As a
sir.
matter of fact, what did you write after you talked about going through the quote retarded client's phone?
Objection.
I'll allow it.
No nudes so far.
No nudes so far, correct?
Correct.
And you said that to your bosses.
Yes, sir.
You were looking for naked photographs of Miss Reed on a Wednesday night as you sat in your office at 9:44 p.m., correct?
No, not correct.
Let me ask you a question. Have you ever looked for naked photos of a male suspect that you were investigating?
I don't look for naked photos in anyone's phones.
But you said you were looking for nudes of Miss Reed.
Like I had
correct?
said, Mr. Jackson, it was an inappropriate joke.
See, and that really clarifies it. It just makes it look more ridiculous. Does anyone see my point here? When Lally's going it through with him and he's like nervous but doesn't he look more relaxed with Jackson? Like, look, it was an inappropriate joke. I'm not proud of it. But once it was out there, he's like, and having Alan Jackson make so much of it, it looks small. How did the defense do the Commonwealth a favor here? I'm still trying to figure out how this happened. Would I prefer to go back in time and tell Proctor to not text anything on his phone because it's going to be subpoenaed and they're going to go through everything? Yes. But now this is the worst that they can get. I mean, even if he was like, don't worry, we're going to get her convicted. I mean, anything that made it look even slightly nefarious. We would know, even if he gave an explanation, that would sink the whole case. But this stuff, calling her the R word and talking about her looks, that's what guys do. Especially, people have brought it up with stressful jobs. So I'm not excusing it. I know this will make the free Karen Reed crowd go crazy, but that's what it seems to be from the beginning to end, from Yannetti's grandstanding from the beginning of this case to the end. Everything seems to be played to the free Karen Reed crowd through the lens of the court TV cameras. You can even see Karen Reed look directly into the cameras often. One time just turning her whole back on the camera when she didn't, and then turning around and looking. And if you notice when he said, I still don't like him, Karen Reed sat up in her chair and sort of opened her mouth agape, like, wow, like she's running the show. So it goes on, but it doesn't go on for very much longer, I don't think. We're right at the end here, just a little bit. Now they have a day break, so Jackson can perfect he knows Proctor's style. He can perfect attacking Proctor, his cross. But what else can they do to him? So now I understand why Lally did it like this. It would be much harder to control in cross-examination.
Sir, this is a citizen. She's a woman.
This is a citizen. This is a woman. She happened to just hit her boyfriend with her car and leave him to die in the cold and then orchestrate an entire defense for herself within 24 hours. It was amazing the way her mind started working immediately to cover her tracks. Film herself hitting John's car, getting her friends together. Never once tried to really save his life, only performed it. This is a really dark, dangerous woman. And if it hadn't been John O'Keefe, I think it would have been someone else. And Brian Higgins dodged a bullet here.
You were supposed to be objectively investigating. Does your text message to your colleagues at Massachusetts State Police reflect an objective investigation of a citizen?
Objection.
You can get part of that question and ask it again.
Do you believe that your text messages were reflective of an objective investigator?
Objection.
I'll allow that. Do you believe that, Trooper Proctor?
I believe poor jokes in unprofessional language have no bearing on the integrity and the facts and physical evidence of this case.
It's not that they don't have any bearing on the facts and integrity. It's that they have no place in a professional investigation because it shows bias, right?
Objection.
So I have to sustain that as asked. Go ahead and ask it differently, Mr. Jackson.
You weren't so much as objectively investigating Karen Reed as objectifying her, correct?
Objection.
I'll allow that.
Isn't that right?
Rephrase the question, please.
You weren't so much as objectively investigating her as objectifying her in those moments, correct?
Again, Mr. Jackson, it was a poor choice of words and a joke that I should not have texted out, but from the start of the investigation, we didn't know what we had.
And your Trooper Proctor, your point in saying no nudes so far to your colleagues in Massachusetts State Police was to suggest that you were looking for nudes and you'd update them when you found them, correct?
Incorrect.
Well, let me ask you a question. Did you find any nudes?
Again,
Karen Reed?
I didn't go through the photos, sir.
Did you find any nudes of Karen Reed?
I didn't go through the photos, sir. I
You
came,
weren't successful.
So isn't this so unfair that as soon as he found conversation with Karen Reed and her attorneys, he had to stop, but they could just go through every aspect of his phone. So it's like not exactly fair, but okay.
In your quest.
I came across text messages from Miss Reed to another attorney on January 29th, so I had to stop looking through her phone.
So you got sidetracked before you could get to the naked pictures of Miss Reed. Is that what you're saying?
Sustained.
To be clear, when you sent those text messages on that group chat, those text messages included, as we said, or as you said, not one, but two of your supervisors, correct?
Right.
Were you ever reprimanded for your conduct in sending that text message?
Objection.
So that's sustained. Do we need to go to sidebar based on what you told me earlier?
We do not.
Okay, so,
I'll ask it a different way.
okay.
Did either Trooper Fanning or Trooper Buchanan dress you down in a responsive text message in that text thread for doing something so abhorrent as looking for nudes or referring to nudes of a female suspect or subject of your investigation?
I mean, like he didn't defend Kevin Spacey. It's just Alan Jackson, the prude. Never heard of a joke before.
Ever happened?
Not that I can recall.
As a matter of fact, in reference to one of the text messages in this same string, your boss, Yuri Buchanan, actually responded to the photo of Mr. Yannetti, didn't he?
Objection.
I'll allow it.
He did, sir.
After you received the photo, that's when you said, I'm, quote, funny, I'm going through his retarded client's phone. Is that right?
Objection.
Allow this, but not too many.
Sure. Is that correct? It's on the top of page
Yes, sir.
685.
That's correct.
And Yuri Buchanan liked that comment. Funny, I'm going through his retarded client's phone.
I see you laughed at an image here, sir. I can't tell if he liked that comment, sir.
Can I approach?
Yes.
All right. So that's really, I think, where we're going to end for today. But you get the idea. He's coming back on Wednesday for more of this. We're off tomorrow in trial, but Wednesday, Thursday, Friday, full days in the Karen Reed trial. And I just wanted to show you a little of it. If this is the big bombshell that they have, that no jury could convict after they heard this, I'm not certain that this is the winner, but I don't know. I'm not the most unbiased eye. I don't know how the jury is feeling. It certainly doesn't answer the question, how did he have the motivation, will, or access to plant evidence in this case? The opportunity, the motive means or opportunity, where's the opportunity to plant evidence in this case? I'm going to end this stream the same way I ended my stream of the trial today with Masshole Mafia, Troll Mafia, their song. They're getting really good. Kate's song is getting really good with these AI songs on this case. And she did a kind of grunge rocker hit on the Karen Reed case, just to remind everybody what this case is all about. And all the lyrics are Karen Reed's own words. Have a great night, everybody. Please hit the thumbs up, subscribe to the channel, share this episode, Leave me a 5-star review on Apple Podcasts, and I'll be back Wednesday morning. Have a great night, everybody.
Who might have done something? Could have hit him. John's dead. Carrie. John's dead. It's snowing. I think he got hit by a plow. I hit him. I'm covered in blood. I had my period. Did I hit him? Jen, this is all my fault. I hit him. Did I hit him? I hit him. My tail light is broken. Did I hit him? I hit him. Is he dead? I hit him. I was so drunk I don't remember. Going to your sister's last night. We got into an argument. I hit him. We got into an argument. I was so drunk I don't remember. Did I hit him? I hit him. Carrie. Google how long it takes to die of hypothermia. I hit him. I thought that I somehow incapacitate him unwittingly, and in his drunkenness he passed out. I said I hit him. It was preceded by a did, and preceded with a question mark. Sunlight is the best disinfectant. Did I hit him? I hit him. Could I hit him? We're all in on the same joke, right? My tail light was smashed and John was pulverized. He was frugal. John's dead. It's snowing. I think he got hit by a plow. Google how long to die in hypothermia. We know who did it, Steve. We know you all know I hit him. We know who did it, Steve. We know, you all know. I hit him.